And good morning, I'm Dan DeRose with 19 News Now, coming to you from our digital desk. We're going to be taking you down to court in Akron for the sentencing of this man. You're looking at Aaron Rittenauer. He pleaded guilty last month to one count of involuntary manslaughter. This was a shooting at a bar in Akron back in April of this year. Rittenauer shot and killed Tiffany Ross. He was originally charged with murder, but has entered into a plea deal to be sentenced today on involuntary manslaughter. He was found a short time later in that area, hiding in the back of a pickup truck the night of that shooting back on April 8th. It was about 1:10 in the morning. Let's take you live into court now for the sentencing of Aaron Rittenauer.
Be present for the sentencing. Got to turn my microphone on. Sure.
Good morning, Gretchen. This is Felicia from the prosecutor's office. Would you like to make a statement this morning at the appropriate time?
She's muted. She's muted.
Yeah, you're muted, Gretchen.
Ms. Carey, if you do, you can start your video and start your audio.
Sounds like the court is welcoming in some Zoom members. Remember, in sentencings in Ohio, there is a chance for victim impact statements, family members, friends who get a chance to influence the judge on just how harsh of a sentence that man should get for the death of Tiffany Ross. They can be very emotional and very heated. You never know, never sure what we're going to get in these sentencings. So we'll keep a close watch.
All right, she can always log off and log back on. Did you take the courtroom out?
I did not. I did earlier, but
Why is it so small now?
maybe because there's only 2 participants. There's a 3rd participant.
Ms. Carey, can you hear us? If you can, would you start your audio and unmute yourself, please?
Dan DeRose again with Channel 19. As you can see, where the court is having some problems getting some Zoom individuals into this sentencing. Court trying to do everything they can to make sure friends, family who want to Zoom in and see the sentence have a chance to speak.
Are you able to see where it says participants or chat and just click on that and find your name and unmute yourself?
Ken, are you unable to mute her or able to unmute her?
Click on mute and nothing happens on correction.
Yeah, you could sit down. It's going to be a minute. Well, how about if we have her call in?
Oh, and she's, okay. Okay, give me 1 second. I'll text
I don't know the phone number though. If she doesn't, instead of doing this, right? Isn't there just a phone number she can call, Ken?
There it is.
Yeah, that's fine. If not, if she just wants to listen, that's okay.
Oh, and she said Sarah can't hear anything.
Sarah has not joined with audio, so.
Okay.
Oh, I apologize. I did get something from Tiffany. Just a statement to the PSI writer.
Okay, perfect.
Oh, and that's from Gretchen.
Oh, perfect. For the courthouse.
You guys need to, like, come up with a...
Okay, I think you could hear me now?
I can.
Yes, we can hear you now.
You need to come up with a page on step-by-step instructions and send it out.
It was my setting.
No, I'm sorry. I was talking to the prosecutors in the courtroom, Miss Carey. Thank you. Miss Carey, do you wish to make a written or an oral statement? I did receive the information that you provided the probation officer who completed the pre-sentence investigation. But if you wish to make a statement now, you may.
I'm not sure I could read it.
Okay. Do you want me to read then what you indicated to the probation officer?
Please.
This says, I am Tiffany's older sister. Honestly, this is super hard to write, so I'm deciding to keep it short. I don't know if you deserve any of our backstory. I've rewrote this so many times. Just unthinkable to have to write this at all. I say you got it easier by taking a plea, but I think you got out of answering questions we don't have answers for and probably never will. I don't know if you are remorseful. I have seen or heard none. I hope one day that you at least explain the truth that we know bits of, yet I'm doubtful that this will happen. I was looking forward to my reunion with my sister that should have been happening right about now. We sounded a lot alike. We took that. You took a mother, a sister, and an aunt, and the one that hurts the most is someday a grandmother. Truly tragic. Ms. Carey, anything else you want to say?
Not at this time.
Thank you.
I'm not sure Tiffany's other sister could hear if she could get in there yet.
We're trying to get her to, she's got to connect with audio, and it appears she hasn't done that, which is why she's unable to hear. So I'm not sure if you could maybe text her, and she can do what you did, which is if you called did she call the number?
No,
Oh,
I'm texting her now, trying to
okay.
guide her.
Okay, I'm telling her what to do right now.
Okay. Look like she might have left and she's going to come back in. Technology. Oh, she's connecting with audio now. There you go. Can you hear us now, Miss Lapis?
I'm sorry?
I was asking if you could hear us.
Yeah, I can hear you guys now.
Thank you so much. So, Miss Carey has already made a statement, or I've read her written statement into the record. Is there anything you'd like to say before sentencing?
No, I just want him to get what he deserves.
Thank you very much. Ms. Easter, on behalf of the state of Ohio.
Thank you, Your Honor. Your Honor, procedurally, the state has received a copy of the pre-sentence investigation report. I went through it and read it, and I don't see any deletions or corrections that need to be made. Your Honor, the defendant did plead to several counts. The main one is the amended murder to involuntary manslaughter. There is a recommendation to the court for 20 to 25 years and a half in the Department of Rehabilitations and Corrections. That is an agreement with no judicial release. That he does all that time. And that was made, that agreement was made for the facts, some facts of the case and the status of some of the witnesses. Now, Your Honor, I would like to talk about the defendant's statement as to what he committed and why he committed this offense, Your Honor. And I know the court has read it, and I was shocked. I briefly talked to the defense attorney prior to the sentencing that I was shocked. I'm shocked. I have to give the court a brief background of the facts, Your Honor, to put it in context of why I'm shocked by the statement. This incident, this shooting, this murder occurred on April 8th of 2023 at approximately 1 a.m. in the morning at the Heights Bar and Grill or Heights Cafe. At that time, Your Honor, the defendant and his girlfriend, Benicia Wood, were there. The defendant was drinking beer and he had his gun in the bar. He gets up and goes and calls the victim, Tiffany, down to the bar. When she gets to the bar, they go to the bar, they drink, there's a bartender there, and they're having a good time. And the bartender states he turns around, he hears a boom, he turns back around. The defendant is going out the door. He looks over the bar, and Tiffany, who's just a young age of 44, is laying on the floor. That's a brief synopsis of what happened, Your Honor. After that, the defendant runs to his friend's house around the corner, barges in his house, wakes him up out of his sleep, tells him he just shot Tiffany, and asks him to give him a ride. Okay. In this car on the ride, he lets him know what happened and continues to let him know, and his friend starts to believe him. They go ditch the gun. While he's in the car, he gets rid of the shells from the revolver in the car, and they ditch the gun, or the defendant ditches the gun in the woods. Then he gets dropped off a block away from his house, where he then walks and hides in the bed of his truck, and that's where he's found hiding. Now, when you read his defense, the statement of what he did and why he did it, excuse me, Your Honor, he forgot he had the gun in his pocket. However, the gun was so big it was sticking out of his pocket. Now, this is a man who was walking around the bar from the witnesses, walking in and out, in the bathroom, out the bathroom, on the phone, but he has a gun so big in his pocket that it's sticking out, but he forgot it. And I'm saying this because after reading this, the state believes he is still not taking responsibility for his actions. Not just that, Your Honor, he says that he starts spinning it around on his finger once he realizes that he has it in his pocket because he was going to take it out to his car, but he starts spinning it like John Wayne. That sentence caught my eye, Your Honor, because everyone in this case, from his girlfriend to his best friend, Jeremy Harper, whose house he ran to the bartender, all say the defendant has multiple guns. And we found multiple guns at his house when we went there. And that he knows guns. He knows the safety of guns. He knows how to act around guns. He knows how to be around guns. So much so that Jeremy Harper said that he let the defendant teach his own son about guns and gun safety. But this defendant saying he's spinning it around his finger like John Wayne, and when he go to grab it, his hand just happens to land on the trigger. Now this is a revolver, a double action revolver that takes a lot of pressure to pull the trigger. So his finger lands on that and just happens to pull it when it's pointed towards the victim. And I say it that way, Your Honor, because this victim was shot in the face at a downward angle from front to back within 2 feet of each other. We know that because of how much stippling was on her face from the medical examiner. And he calls it an accidental shooting. And the facts after the shooting would not be indicative of an accidental shooting, meaning fleeing the scene, meaning hiding or tossing the gun and hiding in the bed of his truck. This is an individual who does not have much of a record. When you look at the report, hardly anything actually from juvenile to adult, if any. Traffic offense. And the other two individuals, the female, his girlfriend, was there, steady screaming, and the bartender describes his behaviors at a time. Those are the individuals who, quote unquote, was there and witnessed it, or maybe not witnessed it, but was there. The individual who did the accidental shooting, however, had the wherewithal to do all this other stuff afterwards, but you accidentally shot someone in the face within 2 feet from someone. So to say I'm disappointed in what you did and why you did it, and to stay skeptical about the level of remorse, but that is for the court to decide. And it's not going to change the facts that we had at the time of sentencing and the witnesses, and that's why the state agreed to 20 to 25 and a half years agreed time in the Ohio Department of Rehabilitation and Corrections. Your Honor, no judicial release at that time, but the state, based on the facts as we know it, that statement in this pre-sentence investigation report is one of the most shocking that I've seen.
Thank you. Mr. Ray.
Your Honor, may it please the court. Judge, as he sits here today, Mr. Ridenauer is 29 years old. As the court is aware, having gone through the PSR, and I have reviewed the PSR, Your Honor, and I have reviewed it with Mr. Ridenauer, Judge. Going through the PSR, the court is aware of the fact that his only prior incident is a traffic speeding that the court, that's still pending, Judge. Other than that, he has absolutely no kind of prior record. In this kind of a situation, Judge, where you have an individual who comes before the court, originally charged with murder and now looking into manslaughter, I don't think there's too many times, at least in my career, I've never had too many times where an individual has absolutely no prior record given those charges, Judge. He does have family support. Last time we were in court for the change of plea, his sister was here. He does have a brother and he has another sister who is supportive of him. His mother and father have passed away. I believe they both passed away from cancer shortly before in 2021. Your Honor, the young lady in this case who passed away, who was shot, she was someone who had helped Mr. Ridenauer. She was a friend. And if you look at the report, aside and apart from what was pointed out by the prosecutor, under Part 3, any additional statements, she was a friend to Mr. Ridenauer. She had helped him locate housing when he was homeless after his mother had passed away from cancer. She had helped him out. His statements that he ran away afterwards, he had no kind of prior record with any of this, Judge. He panicked. He ran. All of that being said, Your Honor, this was an agreed upon sentence. The agreed upon sentence is, I believe, 20 to 24 and a half, 25 and a half. So all of that being said, Judge, I would ask the court to impose the sentence that we had agreed on at the time of the change of the plea, Judge.
Thank you. Mr. Ridnour, would you like to make a statement before sentencing?
No words will be able to make up for the devastation and grief that I caused. I didn't mean for this to happen. Tiffany was a great person, had a great heart, and she looked out for my family when nobody else would. I did not mean for this to happen. My carelessness cost somebody's life, and I didn't mean for this to happen. I'm so sorry, and I'll be sorry for the rest of my life. I hope that someday the family can forgive me for the pain that I've caused. I look forward to getting rehabilitated and going to prison to better myself, to get alcohol treatment, drug treatment, and any type of program that can better me as a person and take care of some of the issues that I had coming up. Again, I'm very remorseful. I'm very sorry for the devastation and grief that I caused your family.
Well, if this is how you look out for a friend, I would hate to be your enemy. You say that she looked out for you, she took care of your family. If it truly was an accidental shooting, why would you run? Why wouldn't you stay there and try to render assistance? Why wouldn't you call 911? Why would you throw the gun in the woods? Why would you do all of those things? If you were truly, truly sad that it was an accidental shooting. To me, none of that adds up. And to say that because you haven't been part of the system before, you didn't know what to do. A human being knows to call 911 when someone's injured. And you chose not to. You chose to run and try to avoid capture, detection, whatever it is. Then, during the process of all of this, while I understand that there are defenses to cases, the first I heard was the gun was probably inoperable. Then we had to test it to make sure it didn't misfire. Meanwhile, the whole time, you shot her in the face, whether intentionally, accidentally, whatever. But it's your actions after that just offend this court and our community. I hope you think about it every single day for the next 20 years. I hope you live with that grief. I hope you do something with your life eventually, because you will be, at a minimum, 49 years old when you're released from prison, if you're released at your earliest release date. If not, you'll be 54 years old, or 55 when you're actually released at the end of your maximum sentence, if you're not released early, based on the minimum and maximum sentences. I truly am empathetic for the family of Miss Woods. I appreciate your willingness to be here and make statements. I know that no amount of words can take away your grief. I can only assure you that as long as you keep her memory alive in your hearts, you will remember the good memories, and this will eventually fade as to the forefront of your lives, which I know it is, and I know going through the holidays will be quite difficult. Based on the facts and circumstances of this case, in consideration of the relevant sentencing factors, applying the minimum sanction I've determined will protect the public and punish the offender without imposing an unnecessary burden on state or local resources. I'm imposing the following. On count 2 as amended, involuntary manslaughter, I'm imposing a minimum of 11 to a maximum of 16.5 years for the crime of involuntary manslaughter. Specification 1 to count 2, the firearm specification, I'm imposing a mandatory 3-year prison term which must be served consecutive and prior to any definite sentence or indefinite sentence that you are ordered to serve. Specification 2 to count 2, I'm ordering that the Taurus 605 serial number ABK 000908 be forfeited. Count 3, tampering with evidence, a felony of the 3rd degree. I'm imposing 3 years in the Ohio Department of Corrections. And count 4, possession of a firearm in a liquor premises, is a felony of the 3rd degree, and I'm imposing 36 months or 3 years on count 4. Counts 2, specification 1 to count 2, count 3, and count 4 will all run consecutive to each other for a total sentence of a minimum of 20 years to a maximum of 25 and a half years in the Ohio Department of Corrections. And again, the first 3 years of that sentence is mandatory and every day must be served. Upon your release from prison, well, first of all, consecutive sentences are necessary to protect the public and punish the offender and are not disproportionate to the level of offense that this has created and the drama, and I guess not drama, emotional trauma to the victims. I also find that 2 of the offenses were committed as part of one course of conduct, and that the harm caused by 2 or more of those offenses was so great or unusual that no single prison term for any of the offenses committed as part of the conduct adequately reflects the seriousness of the conduct. You will be given credit for 228 days served in the Summit County Jail, and upon your release from prison, you'll be facing 2 to 5 years of mandatory post-release control, which is, again, supervision by the Adult Parole Authority. Any violations of the terms and conditions of their supervision could subject you to being remanded to the Ohio Department of Corrections for up to half of your prison term for all violations of their rules and regulations. You are entitled, after serving the mandatory 3-year prison sentence on the firearm specification, to possible good time credit of 5 to 15% against your minimum sentence. The court has a right to deny that good time credit. Before that credit could be denied, the court must conduct a hearing in order to make that decision. Regardless of whether you receive good time credit, you will be released when you finish your minimum term unless the Ohio Department of Corrections determines that you must remain in prison for bad conduct. If you are not released when your minimum term ends, you will serve an additional specified period of time and be given a new release date. You will be released on that date unless you are again denied early release, and this process could repeat until you are released or you finish your maximum term of 25 and a half years. Based on your incarceration and your indigency, I'm not imposing any fines, and I'm waiving the balance of any costs and fees due and owing. And the record will reflect that this was a negotiated sentence. And there at no time will Mr. Ridnour be considered for judicial release by this court or any judge that comes after this court. Anything further for the record?
Your Honor, I just had a question. You had informed the defendant of his PRC rights for count 1.
Oh, so counts 2, you're right. No, so that's count 2. Counts 3 and 4 carry with it 2 years of discretionary post-release control, but as my understanding is any discretionary and mandatory would run concurrent at the same time, but the journal entry will reflect that those 2 counts carry 2 years of discretionary post-release control. Thank you. Yep. Anything else, Mr. Ray?
No, Your Honor.
Good luck, Mr. Ridnour. We're adjourned.
Dan DeRose with 19 News. You've just watched the sentencing of that man, Aaron Ridnour, has just been given 25 and a half years for the shooting of, and I'm going to put it in the judge's words, he claimed that this was an accident, that he was twirling a revolver on his finger when it went off and shot his friend. And as the judge said, if that's how you treat a friend, I'd hate to be an enemy. He then took off from the bar. He found a friend, was running, hid, threw the gun away into the woods. That gun was eventually recovered. It was tested to see if it could misfire, and it could not. So Ridnour saw the writing on the wall to take the plea deal instead of going to trial for murder. And you heard the state say that the angle of the bullet was from up to down, and shot her in the face, and then they determined that it was 2 feet away from her face because of the gunpowder residue on her face, that's how close it was. So this was somebody that was sitting down and a shot from this angle, and it's hard to do that if you're twirling a gun around your finger and it supposedly just goes off. So you can see Ridenour knew what was going on. His girlfriend was in the bar and called Miss Tiffany Ross down to the bar to have some drinks. And unfortunately, it took the 44-year-old's life. Short statements from the family saying they hope he gets everything he deserves. We're going to wrap this up. If we have any other breaking news, it'll be here on our digital platforms. Our 11 o'clock news starting in 45 minutes on CW 43, then our noon news on Channel 19. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media at Cleveland 19 News.